Welcome to Family Law Unfiltered with Emily.
Hey everyone, welcome into an all-new episode of Family Law Unfiltered with Emily Marx. I am your host, Mike Leon. You know, Emily here is a certified family law specialist based out in Newport Beach, California, with over decades of experience in high-stakes family law matters. And she focuses on defending clients against false allegations, navigating guardianships, and guiding step-parents through the adoption process with a direct and unfiltered approach. Today's episode, we're talking about guardianships, mainly how relatives and other third parties can help step in, protect the child when the parents can't or they won't provide the proper care. You know, Emily, it's good to see you. I'm very interested in this topic. And for someone who's never been involved in a guardianship case, what does guardianship of the person mean in the state of California?
Well, thank you for having me, Mike. In California, legal guardian is what you just described. It's where a third party, sometimes a relative, sometimes not, cares for a minor child in lieu of the parents or the parent who would ordinarily care for that minor child.
And that differs, and for the audience out there listening, that differs from adoption and custody orders in family court. How?
The guardianships are decided or determined in probate court, the probate division of the courts. The custody and visitation litigation between parents, that is decided in family court. And then adoptions, in fact, are decided in juvenile court. So they're all decided in different divisions. However, there are provisions of the family code, the California Family Code, that apply to all of those matters. And all of those matters, the overarching theme in all of those matters is the best interest of the minor.
Right. As always.
Yes.
Yeah. Well, so let me ask you on that front, on the guardianship front, who out there can actually petition for guardianship? I'm sure there's a misnomer out there that it's only limited to relatives. Is that, or is that not true? Can other trusted adults apply? Like, how does it work?
That is not true. And non-relative placement as a guardian is permitted. Non-relative does have standing to petition for a guardianship. One difference is that with a non-relative, that non-relative is going to undergo additional evaluations, investigations through social services than a relative would. But certainly non-relatives can petition for guardianship. The most common situation is where a child has been left in the custody or care of a third party. It's pretty tough. I think it would be, with my experience, pretty tough to win or get or have granted a guardianship that doesn't commence with the child living with that person, unless you had the consent of the parents. If the child is in an environment living with their parents, it is very challenging. The client there is going to encounter a contest, objections, and it is going to be very difficult to get or have granted a guardianship. But if the child has been left in the care and custody of a third party, it's the exact opposite. It's easy.
Are there, besides that situation, what other kind of situations out there can you think of, given your experience, that usually leads someone to seek guardianship of a child?
That is I would say, if not 100% of my cases, in guardianship cases, 90% of my cases, that's what happens. In cases where the child is in the custody of a parent, it is very challenging. And I would caution my potential clients against pursuing guardianship in that manner, unless you can get the support, I should say, of social services or CPS. So you would start there. If there's an ongoing Child Protective Services investigation, and Child Protective Services, for example, is threatening to take the child, unless a third party pursues and is awarded a guardianship, even a temporary guardianship, that is a situation the one I just described. That's a situation where the child might not be living with the potential or proposed guardian, but the court would consider granting it anyway. Although, again, if the child is not in the custody of the third party seeking guardianship, it is going to be more difficult. The judge is going to have more questions. That client might get the temporary guardianship approved, like an emergency guardianship approved, but it's going to be more difficult to get the permanent guardianship. I should say, if the one or both of the parents want that child back. If CPS is involved, for example, and a third party is successful in procuring a temporary guardianship from probate court, and that child doesn't live with that third parent when the guardianship is initially sought, then and CPS becomes involved, CPS, their primary goal is reunification. So really, if you have a parent who wants the child, it's going to be very tough to get a permanent guardianship unless the parent is, clearly and provably engaging in behaviors that are detrimental to that child.
Emily, can I go back to something you said a second ago? You were talking about the different courts that handle adoption, guardianship, et cetera. Can you kind of break down again, like which courts actually handle the guardianship cases and how is it different than other family law matters?
Well, it has to do with the parties. A guardianship involves a non-parent, like we said, sometimes a relative, and those are determined in probate. And the reason for that might be the probate code, as you might know, governs decedents estates. It also governs minor child estates. So sort of in conjunction with the governance of a minor child's who inherits money, who wins a personal injury suit, and the court needs to oversee the funds. Kind of concurrent with that, I think that because of the governance of the minor's estates, I think that the jurisdiction over the minor's person sort of is a natural next step. Whereas in family court, most often in family court, the parties are the mom and the dad, not third parties, seeking custody or guardianship of a child who's not theirs. And then in juvenile court, juvenile court has many branches, but in terms of like step-parent adoptions, and we'll talk about those, that's something that I do. The parties there are, we have one parent, biological parent, and then we have the step parent, and those are the parties. So depending on who you are, all of them want custody. So depending on who you are, what role you play in the child's life, that's going to determine what relief you seek and in what court.
Emily, can I ask you, we've talked about, you mentioned that 90% number in terms of the large percentage of your cases and what type they were. But we didn't really talk about like what evidence helps the court in some of those cases decide whether or not a guardianship should be granted. Given your experience, what kind of evidence have you seen that helps the court make the decisions?
In guardianships, in Orange County, and I believe in the entire state of California, probate court investigations are mandatory. So the probate investigator does all of that legwork. As the petitioning party, we just have to plead facts in support of the notion or the contention that guardianship is necessary and convenient. Necessary, why is it necessary? Well, the child's been abandoned in my care for 2 years. I've been taking care of him or her, and I need to be able to enroll the child in school and get medical care. And there are other ways to do that with things like a caregiver's authorization affidavit, but that doesn't give you all the rights that a guardianship does. So that's how you plead it. It's necessary and convenient because the child's living with me and has been, and I need to be able to make decisions in real time. And it's convenient because the child's living with me and I need to be able to make decisions in real time. Now, normally I also include information about the whereabouts of the parents. I mean, that's just kind of the first question. It's a common sense question. Right. But in terms of suitability of the guardian, all of that is done by the investigator. I've never had a case where a probate investigator did not determine that my client was a suitable guardian. Never had that happen. So, my job is to plead the facts in support of the contention that the guardianship is necessary and convenient. And then the court kind of does the rest. They determine the suitability. And if you have those two prongs and it's an uncontested guardianship, the judge is going to grant it.
Yeah.
If the investigator says it's they're suitable, and if we state facts in support of our claim that it is necessary and convenient for the court to order the guardianship, and nobody shows up to oppose it, and we gave notice, it's going to be granted.
Emily, can I ask you a timeline question? Like how if you walk us through the process from start to finish, like how long does it take? Like walk us through just like a typical case, a guardianship case from start to finish.
Sure. Not including temporary. I'll talk about temporary at the end, the sort of emergency. A guardianship petition consists of about, 30 pages worth of paper and forms that need to be filled out and completed. And as an attorney, I do that with my clients. And that's where we're describing, why it's necessary, why it's convenient. We have to name and identify to the best of our ability. If not, we have to supplement it later. All of the people in the child's life who are entitled to notice. This is probably, in an uncontested guardianship, this is the most daunting part, the notice, because you have to give notice to all four of the child's grandparents. Any current legal guardian, never had to do that. I've never tried to terminate somebody else's guardianship in favor of my own. I have had that happen to me, one of my clients, but I've never done that. You have to give notice to the both biological parents, and they're entitled to personal service, personal notice, and sometimes they can't be found. You also have to give notice to the child's siblings, including half siblings. So you've got to dig up these address. They can be served by mail, but all within certain statutory time provisions. So those are the people who are entitled to notice. And so after we file the guardianship petition, sometimes in Orange County, they can take a long time to process, but they do process, and then they get file stamped the day that we submitted the paperwork. It takes me about 4 to 6 hours usually to prepare a guardianship packet. And then it gets filed, and then we get the paperwork back, and it has a hearing date. And that hearing date used to be like 2 months to the day. Now it's 3 months to the day. It keeps getting longer. So I don't know what's going on in probate division, where it's taking a long time for the filings to process. But you get a hearing in 2 months, 3 months, 4 months. And then during that time, the court investigator contacts the potential guardian or guardians and interviews the minor child, interviews the guardian. Sometimes they do a home visit, and then determines whether or not the guardians are suitable. In the meantime, I file on behalf of my clients proofs of service, essentially, of the notices of hearing. And then at the hearing, if the court determines that all the notice requirements were met and has no other questions, even if they do have questions, they might just ask them at the hearing. But that first hearing is the only hearing if it's an uncontested guardianship. So you file, 3 months later, you've got your order and your letters of guardianship. Now, if you need a temporary guardianship because there's an emergent kind of matter, you can get that too. And that's some extra paperwork, but you don't file that instead of the regular petition. You file it in addition to, and then you can get a guardianship or a temporary guardianship within 5 days. But you do have to personally serve the parents, the biological parents, not everybody else. All the other people I mentioned, they're not entitled to notice of the temporary, but the parents are. And so if you can't find them, then you have to make efforts to find them, complete forms, a form called Declaration of Due Diligence or Diligence Search. You really have to show under penalty of perjury that you've tried to find them. So long as you make a good faith effort, judges recognize that, and it's okay. They dispense with the notice requirement so long as good faith effort is made, but it has to be made. So then you get your orders and your letters, and then every year, annually, on the date that you got your orders and your letters initially, you have to file a sort of an update, a status report, just talking about the minor child and how he or she is progressing. You have to attach a report card. The form asks about contact with the parents, because as the guardian, you decide if the child is going to see the parents. You decide if visitation should occur. If you and the parent can't agree, then the parent does have standing to go to court and ask for visitation orders. But as the guardian, you make that decision. So the status report or the questionnaire asks those questions about contact and whether or not, any unforeseen issues have arisen medically or otherwise, educationally. And so long, and you just keep doing that until the child's 18. After 2 years of a guardianship, the guardian is eligible to adopt. But I would say 50% of the cases I've had that have been guardianships are grandparents. They're not interested in adopting usually. They just want to ensure that, their child's child is taken care of.
Yeah. Well, that's great to hear. And I appreciate you breaking down the process for everybody. So let's leave the audience out there. One more piece of advice for someone that is right now listening to this and they're thinking about filing for a guardianship. What would you want them to know about what they should start preparing before they actually go to court?
Contact information for the people entitled to notice. Really, I mean, that is the most daunting requirement. If that person, that potential guardian or who's thinking about filing, has access to legal advice, with a friend or, is able to hire an attorney, consult with an attorney, because the paperwork is so thorough and comprehensive and detailed. You don't want to deal with, or a party doesn't want to deal with, rejections, especially when it takes a month to process a guardianship packet. I mean, can you imagine? It takes a month to process it and then it comes back rejected because, it wasn't filled out properly. So my advice would be to be aware that you're going to have contact information for all these relatives and all these people that I named, and seek counsel, hire counsel if you can, to do the paperwork for you and with you. And if you can't, most courthouses in California offer self-help. I don't know if they're called seminars or what, right. But they, just self-help, evenings, maybe once a month for people interested in pursuing guardianship of the person. Because if the paperwork's not right, there's nothing the court can do.
Yeah. Great advice as always. Emily, thank you for the time, the insights, and breaking this down for the audience. I appreciate it.
Thank you, Mike. Thank you for having me. Thanks for the great questions.
And thank you for listening to this installment of Family Law Unfiltered with Emily Marx. If you're a relative or a trusted adult that is looking to protect a child through a guardianship, do me a favor, visit emilymarxlaw.com to connect with Emily and her team. And one more favor before you go, hit like, hit subscribe, leave a review, comment, share the episode with maybe somebody who's thinking about a guardianship. As always, I'm Mike Leon. We'll see everybody next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.